I will sit back down.
Yeah.
Okay, I've been entertained. Mr. Taylor, do you transcribe word for word everything that is said in this courtroom?
Usually yes. You wanna usually being the key word.
How about nuances?
I mean, it
Like
depends.
trips down the stairs kind of thing.
Uh, I, I, it depends on what it is. If there's
On how funny it is.
it depends
Is this
how
where I
it depends how audible it is. Let's just put it that way.
is this where I pick out my copy of 101 famous poems that I got from my dad and I start reading all of my favorite
And
poems?
they go have to go in the court doc.
I'm sorry.
In the beginning.
Please don't make my job harder than it already is.
We're kind of officially in recess right now, so
Oh right,
everything.
Aw.
Yes, make note of that, please. Did you hear me,
Lieutenant Aiden Snow?
Mr. Snow? Okay. I'm terrible with names and faces.
Yeah, me too. It's fine.
Hello?
There we go.
Oh my gosh. Yeah, since the weather's changed outside, my eyes have been kind of watery and blurry,
Oh,
and my
that's all good.
allergies been kicking up, and I'm having scratchy voice.
Yeah, I hear you. I'll trade you.
Anyways,
And
yeah, we
scene.
don't have any motions per se. We was just really some questions. If we could maybe consolidate this new case with the two we have now, maybe push this off a little bit to allow maybe counsel to pick this up if he wants, since the client he's representing on the two previous cases. I think the defendant's counsel also had something he also wanted to propose. We talked about it earlier, and the state wouldn't oppose. With the mental state of Mr. Loblaw, I believe the defense counsel would like to try to get maybe like a.
Like, I'll make that motion in a
Okay,
moment. Yeah.
Yeah,
But-
just say your bit, Mr. Higgins.
Yeah, we just want to know if we could like consolidate all three of these cases and maybe put it off a little bit. Mr. Loblaw has been quite busy since this first case came available.
Okay. All right. Anything else?
No, Your Honor.
Okay. Thank you. All right, Mr. Furley, your floor.
All right. All right. The defense would like to file a motion for a mental health evaluation for the defendant. It is the opinion of the defense that throughout numerous conversations with the defendant, that the defendant may not understand fully and is not able to discern the difference between what is objectively right and what is objectively wrong. Additionally, it is also the opinion of the defense that the defendant is unable to communicate rationally with legal counsel, citing clear contradictory statements as well as a lack of coherent narratives. In addition, with regards to formalizing any sort of subpoenas for medical records or thereafter providing any self-signed release forms, the officials at SAMS and Schultz General were unable to provide such information as the defendant was unable to coherently dictate their intentions on affirmation form. So we are humbly entering this motion as a judicial order for the screening of the appropriate means of the medical care field within San Andreas.
Hmm. Hmm. What's the defense's response, or the prosecution's response to that, please?
The state is not opposed. If the defense counsel believes that his client's mental status it would be in question, then in the spirit of fairness, we would not be opposed for a forensic mental evaluation.
Likewise, regardless of the determination from said evaluation, the defense would be amendable for consolidation. However, due to the fact that the, how we say, the discovery period has ended for the initial two items, that discovery should not be reopened for, I can read off the designations, one moment.
For the first two cases?
Yes, so for the record, CR-20220911-A, San Andreas versus Loblaw.
Oh, the 0926 Alpha. Please,
Yes.
add that to the record.
CR
The third case being
220926-A, and then the last one would be the most recent.
1013-Alpha.
Correct. Also, the defense would like to have that case in particular be refiled with purely Loblaw and without consideration of Georgie Shards, as obviously guilt should be determined in two different courtroom settings if we are going to introduce outside arguments, primarily for the first two court cases of Mr. Loblaw.
Okay, so Justice Atwater has already claimed the third case.
Oof.
Can you
Okay.
please make a note on the case requesting that either he take all three cases or that he release that case to me so that they can all be seen simultaneously?
Is that something you want me to do, Your Honor, or?
I'm asking Mr. Farrelly to please make a note.
Right, okay.
Okay. Should I stipulate that they? Well, actually, that's okay. I do have a question then. If the refiling were to happen,
It'll all be dated the same date, just
Yeah.
split into two separate files.
so would it be amendable? Oh, obviously, this would be up to the distinction of Mr. Atwater, Magistrate Justice Atwater, on whether or not he will take over Georgie Shards instead of Bob Loblaw, if he can release half of it.
Yeah, I'm sure he, I'm sure he won't mind. We just need to formalize it.
Yeah.
Also, you need to get a hold of Von Karma
Okay. Oh, yeah, for the
and
prosecution.
ask him if he is amenable to splitting the cases. It shouldn't be a problem, but keep in mind it's going to be two different justices.
Okay. All right. Is that should I file this right now, or what is the
Go ahead
decision?
yeah, go ahead and add a comment to the card.
Okay.
Just, just maybe something like, I am requesting that these two trials be split up so that Loblaw, the
Can I put it as an
Loblaw case
injunction?
no, not an injunction, just a
Non-injunction?
request.
Okay.
No, you don't want to injunct. That's not you, that's me.
All right.
We are requesting that this case be split in half so that the Loblaw portion can be attached and combined with the other the other two current cases. Okay.
Correct. I am
You
just
can go ahead
getting
and do
that down here.
Yep, I'll wait for
Yeah.
you, no worries. I mean, if we're lucky, then Atwater will see it quickly and respond.
Yeah.
And I mean, we might actually be able to action it while we're standing here talking.
All right, can I read it out, or should I just formally do it without consideration from the court here?
Add it to the
Okay.
third case. Add a comment to the third case. and
I
then
was just
read-
asking if I should just read it out now and
Yeah,
to
and then
clarify.
Yeah. Go ahead.
Okay. Statwa, we are formally requesting that this case be split by defendants. Mr. Bob Loblaw is currently facing 2 cases citing, I cited both of them there. We humbly request that the portion of this case concerning Mr. Loblaw to be able to be consolidated, and therefore we humbly also request that it be under the purview of Justice Walsh.
That works for me.
Okuli dokuli, Shande.
Okay, excellent. All right. What else we got here? Okay, so you're requesting a mental evaluation. So, I'm thinking, give me a second here.
It's understandable.
Magistrate Justice Atwater has already replied.
Really?
Yep. Saying that I believe this is amenable as long as the state is fine with trying 2 cases for the time of 1.
What is "'cause I'm a boomer" supposed to mean?
I don't know.
I don't
Ron.
believe
He's younger
he
than I am.
notified me, so that's why he just did that.
Okay.
Oh.
Oh, I gotcha.
Yeah.
No, he's not a boomer. He's younger than I am, and I'm Gen X. Okay. Wow. He must have been looking at his tablet right then and there. How's that for timing?
Yeah.
Okay.
Only the world worked like that, that conveniency.
No, that's very convenient. That's very helpful of him. I'm glad he was paying attention. So I'm going to verbalize this, and I'm going to ask for your opinions. For the second case, and I'm torn as to whether or not to into action this knowledge or not. For the second case, I met with Mr. Loblaw. Is it Loblaw?
Mr.
Loblaw.
Loblaw.
Bob
Loblaw.
Loblaw. Like,
Loblaw.
cut it in half and...
Loblaw.
Yeah.
Yes,
there you
Your
go.
Honor.
Loblaw.
Loblaw.
Yeah, blah, blah, blah.
Mr.
It's like how I say Ohana Motives. Like, it's all one word.
Okay. If I start laughing, I'll start coughing, so I'm trying not to laugh
Okay.
too much.
Trust me, this is going to be fucking hilarious on the transcript.
Justice Walsh coughs. Justice Walsh coughs.
Giggles.
just people
Giggles
trying to say
and then-
Loblaw
and
for
then-
5 minutes.
Figure out how many pronunciations of Loblaw we can
Listen, the IPA exists for a reason.
Okay, so I will try to refrain from hitting you with too many Loblaws.
Thank you, Your Honor.
Okay. So I met with Mr. L in the cells for the arrest because he had the second arrest because he had requested a cell trial. No lawyer was available. During this time, Mr. L revealed to me that he was under the influence of methamphetamines and that it was affecting his I'm paraphrasing here, affecting his perceptions, I suppose is probably the best word. Again, I'm paraphrasing. I am wondering if it would benefit Mr. L to also, at the same time as the mental evaluation, to undergo mandatory, well, I don't know if I could do this as a preliminary, but maybe a drug test at the time of the mental evaluation to determine if he is under the influence at the time and use that as a decision whether or not he is capable of perceiving reality if he is clean of drugs at the time.
Yeah.
Does that make sense?
Yes, that would that makes perfect sense. Plus, you know, a trained psychologist or a forensic evaluation, they can determine also whether or not this was he's under a drug-induced psychosis, or if it's a, you know, actual mental thing.
If there's long-lasting damage. If I may, provide also a little bit more context with regards to the second case.
Absolutely.
So I feel like it's a set of unique circumstances that we have seen here. Originally, I was called down on my private phone number. It was assumed that I was actually on retainer with him, which was not the case. I was publicly lotteried for him. I did make amends and did come down to the court to the cells. However, prior to how we say, prior to the determination on whether or not he was going to Bolingbrook or not, I had conversations with him, and he did not. He made numerous claims that he did not do it. He did do it. It was on the lines of he didn't understand completely what was going on, and then I tried to find it. I tried to find it in me to have him also release his how we say, criminal record on his own fruition.
Okay.
But the processing officer, who was, I believe, Duncan Dragons at the time, would not accept the affirmation form as, don't believe I have it here, but it was incoherent.
Okay.
Later, I'm not going to name any names as I cannot remember who was the officer who did approach the cells, but prior to him being sent off for prelim, an officer came and asked if, do you want to do a cell trial? Where it was already determined that he was already going to be prelimed and be go to a regular trial, but they wanted to see justice immediately. So that is when you were called. The defendant stated, okay, yeah, I want to do that. I don't believe he understood what a bench or cell trial was entailing. I did make it known to everybody there that I was not going to be able to represent him in that capacity, as I had other needs to fulfill, if that is
Okay.
understandable.
Mhm.
That is why he was without counsel. The officers then asked him whether he wanted to self-represent, and he said, "Yeah, I will like to do that." Obviously not. I'm not saying it.
Yeah.
I'm saying that's not what he said. That's paraphrasing. So
Okay.
that is what led up to him having that cell trial.
Okay.
It is
That makes sense.
so, in a sense, he did not have adequate representation because of the circumstances. There was no other lawyers present, so other than myself, but I had to leave. Um, Given also that he is technically already given a plea of some degree, an Alfred plea, I believe this this
Yes.
case is extremely unique circumstances as what has transpired.
That's why we're standing here right now, is because I
Yeah.
recognize that there's a lot going on and not all of it is obvious.
Yeah, and I think it's to the point of what the state has agreed to and made a motion for that. I think having a sit down and determining all of these moving parts, right, getting them all formalized would be commendable and would assist in this court setting.
Okay.
I'm still under the impression that the second court case is only a sake of formalities, as he has already put in a plea.
It was an
Um,
Alfred plea.
Alfred plea, yes. Yeah. So I don't know whether or not that should go to
It's not a guilty.
trial.
It's not a guilty plea.
I
And he
understand.
indicated he wanted a cell trial, which means he's entitled to a trial.
Yeah. But he wasn't the one that requested it, though, to my knowledge.
Whoa, who requested it then?
One of the officers that came in prior to him obviously wanting to be prelimed for trial stated, "No, wait, let's hold him. Let me get a command member." And they mentioned that let's take this to a cell trial. I said that obviously I didn't want to do that, so they asked the defendant. Defendant
Wasn't that you,
agreed.
Mr. Snow?
Yeah, I was gonna say I was there the whole time.
Yeah.
I
Okay.
offered it to him. I wasn't forcing it. I offered
Well,
it to him.
If
And
if
it,
I
it became
okay.
more clear as we went on that he wasn't of sound mind, and that's when Walsh arrived, and that's how we got to where we are now.
Yeah. Well, I guess that is just my misconstrued. I My only issue is the fact that we were ready to have him prelimed,
Mm-hmm.
right? He was going to have a trial regardless, but the fact that there was the need to expedite it is what caused the issue.
Okay.
Councillor Farley, could you speak up for me, please?
Did you hear all that, or do I need to
Just
reiterate?
just that last sentence, if you could.
So sorry.
I
Let's
heard
backpedal here.
my interpretation or something like that was the last thing I heard.
So my interpretation of the matter was that obviously we were ready to go to have him prelimed. He would have received a trial, but there was the wanting and the need to expedite it, so that's why it was pushed that we should go to bench trial. Or not bench trial, sorry. Cell trial.
Yeah, so the issue there, I honestly don't remember exactly what transpired. The issue there is there weren't any court charges there were no court charges at that time, so preliminary
Yeah.
wouldn't have been appropriate to begin with. It would have either been an appeal or a cell trial. And
Well, he said that he
thought
did
that's what I
not
was
plead
offered.
guilty, so he would have done a non-guilty plea, is what we determined, and that it would be taken to court. That is that was the
Would've been an
distinction
appeal,
between, I think it's Trooper Duncan Dragons, who was the one that was processing earlier, because he's the one that was who called me down saying, "Hey, I'm processing him. Can you come on down?" And then later he was no longer the processing officer. Someone took over. I don't know if that was you yourself or someone else,
Yeah, I
but
believe it was me.
All right, so I
so
pushed this to court because I could see that something was going on.
yeah,
So
like I
let's
said,
go ahead and take it as it is.
yeah, like I
Um,
said, the refiling would do everybody a favor in solidifying what's going on here.
Okay.
So
All right. So okay. Is there anything else?
Um,
I think we're still waiting on the ruling for the motion on the evaluation.
Mm-hmm. Okay. Is there
Yeah.
anything else related to that?
no, the only thing the state has is if the evaluation is granted, that we maybe have a conference after the results are in.
Of course. Of course.
Yeah.
Do we know who we would like to request to conduct the evaluation? Do we have a psychologist in the city who is qualified?
I believe we would
I'm
have
not-
to reach out to Sam's about that.
Yeah, I don't know if we have one in the state or if we'd have to contract one out of state.
Okay.
If I may, Your Honor.
Of course.
SAMs do not deal with the roster or the hiring of psychologists.
Okay.
They are private. They are private therapists.
Okay.
You would have to try and find them on, on Twitter or something.
Okay.
Okay.
All right, Mr. Forelli, we will leave that to you. And I know that Mr. Taylor very possibly knows a couple as well.
Yes, Your Honour. I've got
Okay,
a list
excellent.
of quite a few.
Excellent. Get with Mr. Forelli after this. I'm going to go ahead and authorize a psychological evaluation, including drug testing, within an hour of the evaluation and completely exactly adjacent to it, so that the psychologist is able to connect up the drug test as it is taken and with the evaluation, and then we'll have the drug test sent to the court privately, since it is no business of the psychologist at the time. If that makes sense.
Just to clarify that the drug analysis should be done after the psychological
Either-
review, or is
either-
it before?
Either before or after with the psychologist present, so that the psychologist goes either directly after the interview or directly before the interview and maintains the presence of Mr. Loblaw either before or after the drug test, because I don't want him being interviewed if he's high on drugs.
Understandable. Is there a certain threshold? Obviously, drugs have long-lasting effects even after consumption and after a day. Is there anything? I know this might not be something of the court's opinion, but rather maybe a medical professional who can give a determination on whether or not he's being impaired. Because if we do a psychological,
If he tests positive, I would like to know whether or not he's considered impaired.
okay.
I'm thinking, do you have a way to get a hold of him?
Mr. Labla?
Yes, please.
I
Sorry.
can make an attempt, but I do not believe it would probably be within 24 hours to 48,
Okay.
if any.
Yeah, see, the problem here is I am no expert on drugs because I have never done them.
I don't
So
think
now
doing
I-
drugs makes you
Yeah,
an expert, though, if I'm being honest.
I wouldn't have the first clue how long you have to be
I-
clear of drugs.
Can confirm it doesn't make you.
Go
an
ahead,
expert.
Mr. Go ahead,
one?
Mr. Taylor.
Mr. Taylor, you do drugs?
Did. I experimented in college a long time ago.
Oh, okay. Can we enter
Wow.
him as an expert?
As
No.
an expert witness.
No.
No, he's my court clerk. You cannot have him as an expert witness.
Which drug? Meth? I think meth is a while. Okay, and clears out really quick.
I think meth is the one we're worried about. Let me look. Hold
Yeah.
on.
Would that be probably something a determination through the SAMs that regard, or would that probably be
It probably
something
need
else?
to be tested at Schultz by
Yeah.
a doctor, and then after the results come in and doctor, goes through the results, then he can, determine whether
I
he's
hear an alarm going off.
high enough to or sober enough to proceed with forensic evaluation.
What is going on back there?
No idea.
I'm looking. Give me a second.
And if I may inquire, with regards to obviously performing these things, we will reference this probably a comment on the docket as justification for doing these. It is a court order, or will there be an affirmation
It will
provided?
be. Yeah, I'm gonna want an affirmation.
Okay.
Mr. Furley, I hate to ask this of you, but can you find out from a member of SAM's at what point methamphetamine will not be detectable
Are we out of the system, or
in
was
a
not?
blood test?
Okay. Let me see. Should I do this in chambers, or can I just do it right here?
Go ahead and ask, and then use that time period as the basis for how long, and communicate with Mr. Loblaw. Let him know that he needs to be clean for that many days before being tested, and then the psych evaluation.
Okay.
So if it's a week, go to Schultz. If they say, yeah, you have to be clean for a week, then let Mr. Loblaw know you need to be clean for 1 week. Then you're going to be blood tested for meth or for drugs. And meth is the one I'm worried about, and I'm pretty sure it's going to be one of the longer lasting ones.
Especially if it's a habit. If he's doing it consistently, it's probably going to be a long time.
Yeah. I would like to point out, though, if he does have diminished capacity, I don't know if just asking him will he. I don't think if we just
Okay, well,
ask him not to do meth, he will
find
stop
out-
doing meth.
Well, find out from him. Let him know
Okay,
if he
when was the last
does
time?
not, then he's going to be sent to prison
Yeah.
or
Can he be
for XYZ. Yeah.
can he be reprimanded until his testing?
I mean, if we need to commit him for prior to the testing, I think that's potentially down the road, but I'm not going to do it
Okay.
right now. I'm going to give him a chance
that would be
to-
something if it couldn't if there has been failed attempts, then we would
Yeah,
push
if
for
he
reprimand.
fails the
Yeah,
drug
yeah.
test, we would ask him
'Cause
to
it-
be reprimanded.
Yeah, because that's violating the court order, and he
Yeah.
can't complete the court order unless he's sober. So,
I'm getting the impression that he's not going to respect the court order anyway. So
well,
let's give
benefit
it a
of the
shot.
doubt. Yeah, let's give him benefit of the doubt.
We're gonna give him the benefit of the doubt. I know it's hard. I know it's hard. I mean,
Yeah.
I dealt with them all, for many, many years in Miami. I've seen my share. We're just gonna take one step at a time here, and give him a chance.
Counsel, it is worth mentioning because I don't believe you were present when he initially mentioned it. He did reference it. He did call it medicine at first. He did later clarify it was meth, but if he says medicine, chances are he means meth.
This is understandable. I believe there are other references he has made in the past that I can deduce on whether or not he may or may not be sober. So I will find it expendable, and I will attempt to have this push forward.
Okay.
And I will contact member of Sam's to get our window, and then I will communicate that on the docket so everybody knows
Excellent.
what the window of time of being sober would be, as to give us a good plan on when this court order can be established and rectified.
Okay, here we go. I found it. Methamphetamines have a half-life of 9 to 24 hours. Typically, the detection interval in urine tests is 3 to 5 days. So let's tell him 6 days. He needs to be clean for 6 days and then get tested, and he needs to coordinate that test with meeting up with a psychologist.
Okay.
If you have to tie him to a chair to do it.
I
For
don't want
legal
to be
reasons,
charged
that
for
was a joke.
unlawful imprisonment.
Yeah, for legal reasons, that was a joke.
Okay.
To confirm, are we asking for a urine test or a blood test, Your Honour?
Let's go for a urine test.
Okay.
So I do not need to reach out for Sam's with regards to the
Well,
time
they'll
frame, just for the actual testing.
Yeah.
Okay.
Yeah, reach out. So reach out to Mr. Loblaw for the urine test. Let him know he needs to be clean for 6 days before he goes in. If he fails, if he claims he is clean and fails the test, it's going to be a violation of a court order, and he's going to pay a penalty for that. And then we're going to start it all over again. We're going to try it again.
At what point will reprimand be enacted? After how many attempts?
Two strikes and you're out.
Okay.
If he fails it twice. Okay. All
Alrighty.
right. Anything else?
Not from the state, Your Honor.
And nothing from the defense.
Okay. All right, so we're going to call this case closed for now, and we will revisit. Do not close the cases, Mr. Taylor. We're going
Okay, Your Honor.
to put them on hold for, I'll give you 10 days so that way you'll have 4 days to get a hold of him and communicate to him that he is expected to remain clean for 6 days, then go in for a blood test. Okay? He's also going to need to find a get with Mr. Taylor. He's going to need to find a psychiatrist or psychologist to get to work with.
So a member who can perform the evaluation.
Yes, please.
Okay. So I'm just going to read
Okay.
that back. I have approximately 4 days to reach out, and he has 6 days, or 10 days in total, technically, to have his evaluation.
If it goes a little beyond that, I'm okay.
Okay.
I mean, I don't want to be unreasonable.
Yeah, it's agreeable, and
I mean,
we
people
appreciate it.
have schedules,
Yeah.
and including the members of SAMS as well as the members of the psychology community. Just a second.
Just fell over his medical
Okay.
right out front.
What?
Oh.
Yeah, Rocky, can you check that? What title's there? Sorry, I just got the alert. It's total. Anyway.
Sorry. I'm breathing down the wrong pipe, and it doesn't help when you've got a sore throat.
Oh no.
Everyone okay out there? What the?
I don't know.
Must be the pumpkins.
Oh yeah, they were jumping on the pumpkins.
We should probably
what?
Yeah, there's
unplug
a-
that from the main electrical
There's a
line.
pumpkin directly connected to the main warehouse
Oh
supply.
boy. Well, that's not a good thing.
Yeah, they have the same thing. They did the same thing over at Schultz.
Okay. All right. So anything else?
Defense does not have anything.
All right. Prosecution.
Nope, the state rests.
Okay, we will go ahead, and continue this case. Get back with me in 10 days, and from there we will decide where to go from there, okay?
All right.
Okay,
Thank you, Your Honor.
thank you, gentlemen.
Yes, thank you, Your Honor.
Okay, we have